Open court.
Oyez, oyez. Silence is commanded for the justices of the Supreme Court of Kentucky while they are sitting. All those having pleas to make or causes to prosecute, draw nigh and you shall be heard. This court is now in session. God save the Commonwealth. God save this honorable court. You may be seated.
Good morning, everyone. Can you hear me? The court will now recognize the Honorable Ms. Deborah Wilkinson of Western Kentucky University for a few words of greeting. Ms. Wilkins.
On behalf of the Kentucky Supreme Court, the Administrative Office of the Court, Western Kentucky University and its Department of Journalism, and the Society of Professional Journalists, I want to welcome everyone today to Western Kentucky University. Interim President Dr. Barbara Birch was called to Frankfort late last night and was unable to be here this morning to welcome you personally. I want to wish the parties and their counsel luck, knowledge, and Godspeed, and I hope everyone enjoys their day here today. Thank you.
Thank you. I'll now introduce to the audience, many of you already know this gentleman. He is William Cooper from Elizabethtown. Bill is a member of this court, and he represents, among many other counties, Warren County. Bill?
Thank you, Mr. Chief Justice. Just by way of explanation before we begin, the Supreme Court of Kentucky normally meets in Frankfort, and we meet and hold oral arguments on a monthly basis in Frankfort. However, every year or so, we go out into the state, as we have done this week, to hold our oral arguments in other communities such as Bowling Green. And we do that for the purpose of education, primarily. I think that most of us know what goes on in the executive and legislative branches of our government because it's covered regularly by television and you can see them in session and know what's going on. However, I think that very few people have an opportunity to see the judiciary perform its duties, except what you might see on television, and that usually has to do with the trial courts. And of course, the Supreme Court is in the appellate system, and this is the highest appellate court. Before we begin today, I would like to introduce to you the members of the court. To my right, representing the 1st District, is Justice William Graves from Paducah. As the Chief Justice informed you, I'm Justice William Cooper from Elizabethtown, and I represent the 2nd District. To my left is Justice Joseph Lambert of Mount Vernon, who represents the 3rd District. Chief Justice Robert Stevens of Lexington represents the 5th District, and to his left, representing the 4th District, is Justice Martin Johnstone of Louisville. To his left, representing the 6th District, is Justice Donald Wintersheimer of Covington. And seated to my far left, representing the 7th District, is Justice Janet Stumbo of Prestonsburg. Mr. Chief Justice.
Thank you. The first case to be argued this morning is Watts versus KSH, a partnership, and King versus Watts. Mr. Herron, you will have 8 minutes, and your associate counsel, Mr. Maloney, will do the rebuttal. Is that correct? And Mr. Miller, you'll have the normal 15 minutes. Gentlemen, what I'll do is when you come within 1 minute, I will get your attention, 1 minute of your allotted time. All right, Mr. Herron, you may proceed.
Please the court, ladies and gentlemen. This jury verdict, this case and judgment is about Chad Watts, who at 4 years of age was catastrophically injured as a result of first an illegal sale of alcohol by defendant's liquor store to minors. The minors, particularly a young man by the name of Todd Neal, consumed it, became intoxicated, and later Neal drove his motor vehicle over 100 yards on the wrong side of a 2-lane road into a curve, lost control, crashed his vehicle into a vehicle in which Chad was a passenger. Chad's father, Dan Watts, was fatally injured in this crash. 2 of the 4 minor boys who were in the car at defendant's liquor store early that morning on November 16, 1984, were available to testify when this case was tried, and that included the boy who went into the liquor store and purchased the alcohol at 16 years of age. These 2 boys had previously given statements to the Scott County Sheriff 8 and 10 days respectively after the wreck. The statements were given in the presence of their parents. They each hand wrote the statement. Those statements are attached as appendices 6 and 7 to our brief. Therein, they both separately and specifically identify the Newtown Spirit Shop, the defendant's liquor store, as the store where they stopped, parked directly in front of a glass front store, and where Doug Charles, the front seat passenger, went in and purchased a case of Budweiser beer and a pint of Bacardi rum at or about 10 a.m. in the morning on November 16th.
Wasn't there also some testimony that the car may have been around the side of the liquor store, out of the sight of a clerk?
I recall some testimony from the defendants as to how they typically had their store arranged with some boxes in front, trying to provide a potential excuse to the manager. But as I recall the layout of that store, it had a drive-in window to the side, and I don't know how you could have been to the side. I believe Doug Charles testified and Harold Brandenburg, who both testified that it was in front. That's my recollection, Justice. Doug Charles, importantly, did not have a fake ID. I asked him about that at the trial and what he would have done if he had been asked for identification, and he said that he would have either walked away or just shown his actual driver's license, but it was not requested. The alcohol was consumed, Neil became intoxicated, and the start of this tragedy begun. Suit was filed. Now, stepping over into the legal side of it, the procedural side of it, suit was filed on behalf of Chad and the estate of the deceased father against Neil, the driver, and his parents, and the case was promptly settled without reaching trial or judgment. After further investigation and research and conducting interviews with witnesses, a case was brought against the defendant liquor store in January. First, a letter was written to him in January of 1988. That would have been 3 years and 3 months after the sale and the tragic event, setting out the details of our investigation, the sale of the beer and rum, the identity of their store, the blood alcohol testing, and our intentions. And a lawsuit was filed 2 months later. The case was tried in the Scott Circuit Court before trial judge David Knox in November of 1992. The jury found that a sale occurred at the Newtown Spirit Shop. This was an additional aspect of the instructions that the defense asked about because they defended the case on a theory that perhaps they didn't buy it at Newtown Spirit Shop, even though these boys had clearly identified that shop 8 and 10 days after the wreck. So we agreed and allowed that to be put in the instruction. We also proved that the sale was without use of inducement by false identification or means. The jury found that in response to the instruction, that Doug Charles' appearance did not indicate that he was of legal age, and importantly, that the sale by KS&H was a substantial factor in causing the motor vehicle accident and the tragic injuries to Chad. A duty and apportionment instruction was given to the jury, including the fault of Todd Neal. The jury apportioned 70% of the fault in this case to the driver, Mr. Neal, who was a prior settling tortfeasor, as we know in the law, and the jury apportioned 30% of the fault to the liquor store. This case has reached this Supreme Court because the Court of Appeals believed and found that because the prior case had been filed against Neal, that this somehow was an impermissible splitting causes of action in filing this separate action. The Court of Appeals is wrong. They have erred for 3 significant reasons. The principle that they use does not prohibit a plaintiff from bringing separate lawsuits against separate parties, particularly where there's an apportionment instruction, as in this case. The only application of the rule requires identity of parties, which we did not have in this case, identity of causes of action, which we did not have in this case, and a prior decision on the merits, a prior judgment, which we did not have in this case. We have cited many authorities in our brief concerning this issue. The most recent, probably known to this court, is the case of Capital Holding versus Bailey. That's an asbestos case that came out of Louisville, where Mr. Bailey was exposed to asbestos while working at the Capital Holding building there. and he brought a case both in tort of outrage for severe emotional distress and for his injury damages. And the plaintiff's lawyer in that case was worried about including all the claims in the case, and this court indicated, no, the injury case hasn't accrued yet, so we're only going to address the tort of outrage case at this time. So in that case, though, importantly, it's the same parties. In this case, we don't have the same parties as in the original case. Probably the most on-point case is the case of Arnold versus Kmart. That's a case that arose out of Lexington and Fayette Circuit Court, where Arnold was discharged as an employee of Kmart. He went down to small claims court and filed suit for his paycheck. He got a default judgment against Kmart for $882, and then subsequently filed in circuit court wrongful termination, labor violation, and slander and defamation type action. And the court ruled, in that case, you have identity of parties, which we don't have here. And in that case, that was not ruled to be an impermissible split of causes of action.
Excuse me, but the Court of Appeals found some significance in the fact that by handling the case the way it was handled, that it prevented the defendants from getting an apportionment instruction or a contribution claim against the estate of the child's father for failing to have him secured in seat restraint.
One could glean that from the opinion of the Court of Appeals, Justice Cooper. However, Judge Knox, there are several reasons why that is so wrong with respect to this trial. First of all, at the time this case was tried in 1982, there was a statute in effect that said that you can't use the fact of the lack of a child restraint. It was KRS 189125, Section 5, 1982 statute applicable at the time this case arose in '84, that says in Part 5, failure to wear a child passenger restraint shall not be considered as contributory negligence, nor shall such failure to wear said passenger restraint system be admissible as evidence in the trial of any civil action. That was the law at the time. However, the truth of the matter is we didn't even bring that up. The judge ruled at the trial that they had not met their burden to introduce any evidence that Dan Watts did anything wrong that justified an instruction. Judge Knox entered a finding to that effect.
Weren't pickup trucks also exempted? Didn't I read that in one of the briefs?
Exactly.
And
exactly.
They were in a pickup truck?
They were in a pickup. Watts were in a pickup truck. And that is exactly true. Moving on, the court well knows that this case and the law that was the basis of the underlying alcohol liability action was based on Grayson versus Fraternal Order of Eagles, a case written by Justice Lambert in 1987. The bottom line on this is that
Justice Liebson.
Justice Liebson?
Yes.
I'm sorry, Judge.
Joined by Justice.
The court found that the question of proximate cause, which we all know proximate cause is the same as substantial factor, and I believe it's that case that actually makes that decision or progress in the law. The question of proximate cause is a factual one, not a legal one, depending on whether the evidence shows that the results of the misconduct are reasonably foreseeable. That is a jury issue that the jury found in this case. You know, actually, when you look at the alcohol statute, KRS 2440801, which forbids the sale of alcohol to minors, and you look at the cases like Loma Yestawa. Thank you, Your Honor. All right. Thank you.
Mr. Miller?
Please, the court, I would like to talk about 4 issues. I've even divided up my time, 2 minutes, 2 minutes, 4 minutes, and 7 minutes, but I'll bet you anything I'm not able to stick to it. I do want to say one thing that really applies to all of it, and that is how the facts need to be dealt with in this case. Justice Stumbo has commented on this in opinions. Unfortunately, if a fact is stated and it's not in a brief with a citation to the record, you'd be well advised not to rely on it. If it's cited in a brief with a citation in the record, you'd be well advised to read the record. If it's cited in a brief with dots in the middle of it, you better read what was in the dots. Perfect example, Justice Johnstone's example, question this morning about where the car was. On page 9 of my brief, it's there, Your Honor. The testimony was not from my client. The testimony was from the young man who went in and bought the liquor. The fact is, the uncontradicted fact is, that the car was hidden away so the clerk couldn't see it. That's just a fact. And in my opinion, it's a dispositive fact. First issue, I'm going to jump back. I'm responding in a way to a sort of flippant answer I gave to Justice Graves last time we argued this case on what I consider to be the simplest issue in this case. And that is that, again, the uncontradicted facts are that we don't know who and how the blood, which was the critical evidence in this case, which was tested from Mr. Neal, was tested. I've rather flippantly said that surely the most recent case which I cited, which was a DUI case, if somebody could lose his license for 30 days and get it back because we didn't know who drew the blood, surely somebody whose life savings are gone is entitled to that. And Justice Graves said, why should the same rule apply in criminal and civil cases? So I went to Professor Lawson, and Professor Lawson reminded me, as I should have known, that this whole thing is a part of the law of hearsay, which applies to all actions. And experts are allowed to testify, including about blood, only. And I went to the computer today and pulled out the Buckler case and wrote down the exact words. Let's see if I can find it. Only that produced, the evidence can be testified to, only that produced by qualified personnel, end quote. And that case has been cited 22 times since that time, 11 of them in civil cases. The second most recent one in the other case I cited in my motion in an opinion written by Judge Lambert. Same rules, hearsay, everywhere. The second issue I want to talk about is the one that this case was about until the Rule 60 motions were filed. And again, that one came up briefly today. Proximate cause and substantial factor are not the same issues. They are different. It is true that proximate cause is a matter of fact. In this case, it was determined as a matter of law. The common law has always been, as stated in the George case, that selling liquor does not proximately cause automobile accidents. Person selling does not have the duty to foresee that somebody is going to do it. That's changed by George to the limited extent of the per se rule. And in that case, like the trial court believed and counsel would have this court believe, a group of people bought liquor. A group of people did not buy liquor. One person bought liquor. The others were hidden away. The Grayson case, which follows it up, says, as is appropriate and is the rule, the cases we cite in every per se case, per se goes only as far as what the statute says. Such person is the language of that rule. And as the Court of Appeals said, this would be an extension of the dram shop rule. If you had to foresee, as Judge Knox instructed, as a matter of law, and it is appropriate as a matter of law, if Doug Charles had gone out and had this accident. Not in this case, where there was an intervening crime. In any such case, you have to go back to foreseeability. In this case, because the per se rule doesn't apply, we're back to the common law as a matter of law.
Counsel, why isn't it entirely foreseeable that a underage purchaser of alcoholic beverages is going to make a transfer of some portion of that alcoholic beverage to another underage person? Isn't this consistent with the behavior of 16-year-old youngsters? And isn't it foreseeable to enable a jury to make a finding to that effect? It's not what we say about it. It's if a certain threshold is crossed, it's what the jury says about it. Now, why wasn't that threshold crossed?
Well, first of all, that was not what happened in this case. The judge decided. As was
He decided
appropriate.
it should go to the jury.
No. The issue of foreseeability was never submitted to the jury. Absolutely not. The only issue that's in the duty part of the instruction is that if the guy looked like he was obviously 21, that was an excuse. It was foreseeable otherwise. All they had to do is find that they sold it to a minor.
Well, then they had to find that it was the substantial factor.
Yes, but that's a different issue.
And on
Different than
that,
foreseeability?
Oh, absolutely.
You don't think foreseeability is included in
Well,
substantial
I
factor?
mean, let me answer no, it clearly is not. But to answer your question, Justice Lambert, yeah, it happens sometimes, but that's not what foreseeability means. Probably is the test of that, as the cases that I cite say. Not possibly. Sure, it happens. Little old ladies give liquor away to their grandchildren. It happens all the time. Probably more liquor accidents occur when people are in houses where they've been given the liquor by somebody who bought it. When somebody comes to buy a case of liquor, sure, it's going to go home and somebody's going to get drunk and somebody is likely to be driving a car drunk. But that's not what foreseeability is. Foreseeability is probably. And the common law, which is right, is, and it's set out in George, is that it can't be in that way, cannot be foreseen.
you made a point, while you're at a break point here, you made a point a moment ago about saying that substantial factor and proximate, as I understood you, that substantial factor and proximate cause are different. And that's certainly not my understanding of it. In fact, I'm reading now from the Eagles case on where it says, Kentucky law now defines proximate cause in the terminology of, quote, a substantial factor in causing the event which occasions the injury.
Well,
Is that statement incorrect?
Well, it's correct in a sense, but there are two levels. Proximate cause has to do with duty. The case that I think is appropriate, Your Honor, is one in which both sides of the court agreed, the Corbin motor case, which is a 1987 case that Your Honor wrote a dissent in, but both sides agreed that the point of the duty, which is the first part of this instruction, requires a different analysis. If the duty barrier were removed, the trier of fact would be free to consider the issues which should govern liability, i.e. whether the defendant was negligent, and if so, whether his negligence was a substantial factor in causing the injuries and damages. Two different issues.
Aren't those two different concepts, negligence and proximate cause? And isn't duty part of the negligence concept?
Yes. Yes. And the instruction that is in error here is the negligence instruction. Proximate cause, the language proximate cause goes back and forth in the cases. But negligence, I think, Your Honor, negligence, foreseeability, I think, as Justice Graves pointed out, negligence, foreseeability, those all have to do with duty. Causation, in fact, is another issue. And it's correct, Your Honor, that if the facts of this, if all the kids had come in and had been seen, as in the George case.
That the instruction should have said that if he sold it, which was illegal, and if he foresaw or should have foreseen that the driver, Neil, would have consumed it and that it was the proximate cause.
But for...
Did you tender an instruction like that?
But I don't think that's the law, Your Honor. That would require a change. The law is set out in George is that it is not foreseeable. I believe if you read the George case, you'll find that that's the law. I mean, it's just too big a risk.
On that basis, then you were entitled to a directed verdict.
Yes. And moved for it. And Judge Knox said, well, I thought I heard evidence that they bought the liquor. And he didn't. He heard it said a lot, but he never heard it from any witness. The third issue, the Court of Appeals did not decide this based on the cases of the core doctrine of res judicata. That's an analogy just like, and probably less than my argument about latches is an analogy. Splitting a cause of action, and this is something Justice Stumbo was concerned about. I couldn't find when I was up here and answered your question where in my brief I had pointed out that we had argued that below, and there's a page and a half of citations on pages 50 and 51 of our original brief. I was looking in the wrong brief to find it. The rule for which we contend and which we think the Court of Appeals establishes is that if process can be served on a potential defendant, if there's a risk of multiplicity of lawsuits and double recovery as is in every case where apportionment's involved, and if there's substantial prejudice to a defendant that's not brought in, the old rule that's something like splitting a cause of action, the general equitable rule as described by the Court of Appeals, ought to be enforced. When I reread my brief and saw those three things there, it finally clicked into my mind that I was quoting from Civil Rule 19. Rule 19 is in the first case. We're talking about a rule that has to be applied, in our opinion, in the second case, in the Court of Appeals' opinion. CR 1901 says that if a possible defendant is subject to service process, and if complete relief can't be granted, as is always the case in apportionment cases, then the other defendant has to be brought in. The problem is, of course, we didn't know about this case, but even if we'd known about it, Rule 19 issues can only be raised by defendants who've been sued. This case is an extreme one, but it applies to every case. In 1902, even if you can get process on the party, even if you cannot get process on the party, Rule 1902 says that if there's going to be substantial prejudice to the other party on the outside, you got to dismiss that case. So in a sense, what the Court of Appeals said is just a way of establishing the policies of what you've already adopted in Rule 19, but in the second case, as opposed to in the first case. And I think if you think through, which unfortunately we don't have time to do today, the notions of judicial economy and of fairness to parties, which are in Rule 19 and which the Court of Appeals is struggling mightily with in the apportionment area, can be solved by creating an incentive at the time of the first case, which you can also enforce at the time of the second case.
But the problem is that the plaintiff in the second case was not a plaintiff in the first case.
Oh, yeah, same plaintiff.
He wasn't suing for his own, yes, he was, that's right, yes.
Same plaintiff.
What effect would that have, if any, on the fact that the young boy, not Chad, but the 4-year-old was under disability and no suit has to be filed until...
It makes it, Your Honor, absolutely essential in that case that you do this, because otherwise there are no statute of limitations. In most cases, statute of limitations is going to help solve the problem. When you've got a minor and now somebody who's incompetent, there is no statute of limitations. They still haven't sued the ambulance driver who may have caused the worst injuries. They still haven't sued the kid who bought the liquor, whose father may have insurance. There are no limitations.
Isn't this whole problem that you're identifying and talking about now, isn't it answered by the fact that we now permit apportionment against non-parties against whom there has been an active assertion of a claim, and that is defined as, certainly defined as parties who have settled the case? Isn't it, when the jury made its finding, made its verdict here, that apportioned 70% of the liability against the negligent driver? Doesn't that answer the question?
No, Your Honor. In our case, we weren't allowed to get apportionment against the child's father. But in the first case, I mean, the point is they ought to have an incentive to sue us in the first case. That was what judicial economy and fairness to the parties requires. There should be an incentive to get them all sued in that case. They didn't sue us. That's the problem. And without
What you're saying is that while the statute of limitations is told during infancy, if the infant does file his suit, then he's required to name all potential defendants in that suit.
Or not sue him again. I mean, he can choose not to sue him, but not wait 3.5 years until our business records were destroyed. The insurance investigator had a tape of one of these boys who told a different story on tape to him, and he destroyed the tape. There's this problem of the fact that we couldn't sue the estate. Despite what counsel says, Professor Merritt says that we're right about that. They're in the Kentucky case. I list in my brief 3 or 4 other problems. There's no way of looking at the site. The memory of the person who allegedly sold the liquor by the time of the trial was 8 years old. I mean, it's terrible. It's the most extreme case. And when they sue the ambulance driver without such a rule, it's going to be even worse.
Counsel, in this state, there is no statute of limitations for felony prosecutions. From time to time, we see felony prosecutions begin years, decades perhaps, after the crime occurred. We have taken the position that the interest in prosecuting felony crime is sufficiently great to outweigh the countervailing interest occasioned by statutes of limitations. Now, as a matter of public policy in this state, we have determined that the statute of limitations shall not run against an infant or a person of unsound mind, and it shall not run against a person under a severe, profound disability. Now, why doesn't that answer the question you just raised here? It's a matter of public policy which has been given to us by an appropriate source.
Because of the abuse of that policy in this case, Your Honor.
We can all think of circumstances where there may have been an abusive criminal prosecution, but that doesn't forbid it.
No, it would be a defense. It wouldn't be a limitations defense, but in those cases there's an abusive process cause of action and a defense in this state. That's no, I mean, compared to a felony, that's no harder to get at than this one. I mean, this one's terrible, Your Honor. We didn't even know about it for 3.5 years. If we had the records, we don't even believe the liquor was sold there. We know the boys got their story together. We know we didn't have any countervailing testimony. Nobody could remember. But I've defended a whole bunch of ABC cases where my client was able to produce a record that showed on that day, I mean, they're sophisticated with now, but they always showed that on that day, there either was or there wasn't 2 cases of beer and a bottle of rum sold the first sale of the day. Our records were destroyed. There was a tape from the insurance carrier where the kid said, that I went in because I was the oldest looking one and I had a fake ID. I mean, we didn't have tape. And they had every opportunity to file a lawsuit. This is not the Commonwealth prosecuting a felony, Your Honor. This is somebody who had an absolute opportunity, and this court ought to create a duty for doing it at the first time around when it's fair to everybody. Finally, Judge, Chief, how
You
much?
have about 8 minutes.
Okay. I did it. I allowed myself 7 minutes to
Well, we didn't charge you for the colloquy with the bench.
That was the part I enjoyed, Your Honor.
Well, I'll be glad to charge you for it. You can sit down.
If it's a small amount of cash. Your Honor, the issue that I stay up at night worrying about that's in this case is those other issues are important and interesting issues. But to me, the issue that this case has got to be about, and as I was driving down, it occurred to me that I'm using the same words I used in the mahogany courtroom in Frankfurt, but I wonder if they're not words with greater impact in this room. It's very important to those of us in pinstripe suits, and I know those of you in robes spend your life worrying about this issue. The way the law is practiced in this state and the way judgments are obtained matter a whole lot to you and to me and my clients and to those people back there. And I am embarrassed and I'm outraged by what happened in this case. Judge Knox found as a fact, the only fact that needs to be found, and that is that Mrs. Wexel, who called herself Mrs. Watts at the time of the trial, and her counsel consciously concealed from the jury the fact that she was no longer a widow. He found that they did it intentionally. He was one of the main beneficiaries of the fraud, so he had forgotten what was in the record. It wasn't just concealment. It was active fraud and perjury. After Mr. Cleveland objected, won the objection, objected, won the objection, objected, and then lost. So it was, the worst possible thing for trial lawyers. The jury knew it was important. Mrs. Wexel testified, "My husband is dead." These are quoted in my brief, so I'll paraphrase them now. "My husband is dead. I don't have any members of the family around that know what I do to take care of him." And that was a lie. After it was over and we discovered that Mrs. Wexel had in fact remarried, during the CR 60 hearing on a different issue, I asked her what her name was, and she paused and told me what her name was, finally. The defense at that time, in 3 or 4 memoranda, in 2 or 3 affidavits of counsel, was that they had never referred to her as Mrs. Watts. They always referred to her as Elizabeth. That's where the judge who didn't remember got the idea it was just concealment. But the truth is that the court reporter got it right. She was called to the stand, cited in my brief with the page number as Mrs. Watts. One of the most passionate arguments in the case was what the jury ought to do for, quote, the Watts family, and there was no Watts family. There was a Wexel family and a pathetic child who was, frankly, a cash machine for the Wexel family. I'm embarrassed by it. I'm outraged by it. And it goes on and on. This woman has done wonderful things on her own, and now you, the jury, have to be there to help her. I don't know where her strength came. It must have come from the Lord. So blasphemy on the top of outrage. Judge Knox didn't rule for us on that issue, and the Court of Appeals didn't get to it. Frankly, it's appropriate for this court to get to it. This is the court that runs the bar.
Doesn't this issue usually come up in a wrongful death action where the defendant wants to show the jury that the widow is remarried and there's a procedural rule against that?
Sure.
And isn't there usually a motion in limine which forbids the defendant
Absolutely.
from any mention of the remarriage of the decedent's spouse?
Absolutely.
And why doesn't that render this argument utterly irrelevant?
Well, it doesn't make this argument irrelevant. It means maybe Judge Knox was wrong to let her testify about her widowhood. If the judge had not let her say those things, okay, and changed the name, but the name still would still have been a lie. The point is that it's not whether the false testimony was technically relevant. The point is it was done. And that was one of the reasons Judge Knox gave it. That I guess what he was holding was that he was wrong to let it in. But that doesn't solve the problem. It is different than a wrongful death action because the measure of damages in this case has to do with future activities. And that doesn't have anything to do with a wrongful death case, what's going to be required to take care of a child. That was the relevance that Judge Knox found in it. Whether it's right or wrong in wrongful death cases, I don't think it makes any difference. I cite to you a Missouri case that says it's absolutely improper in a wrongful death case, but it doesn't make any difference. You're not supposed to lie to juries. You're not supposed to influence juries with falsehoods, and serious falsehoods, and repeated falsehoods, and intentional falsehoods, over and over again. The second ground that Judge Knox relied on, I find supported by no authority anywhere in any state of any kind, and surely not in Kentucky. And that was that he was not convinced, his word, convinced, that it is what had influenced the jury. I am convinced that that's what influenced the jury.
What's the effect of that determination in on a 6002 motion? What are we to do with that?
Oh, I think you're bound by his determination that it was conscious. And
we're bound by his determination that there was no effect on the jury.
No. It's the standard that's wrong, Your Honor. He didn't find that there was no effect on the jury. He said that he's not convinced that there was an effect on the jury. That's the standard that you apply in a common law fraud case to show that there's fraud. But he didn't find that there wasn't fraud. He found there was fraud. Even in a common law fraud case, you don't have to prove by convincing evidence that there was injury. I mean, you go back to a regular standard on that, but that's not what this is. This is not about common law fraud. This is about fraud on the court. This is about obtaining a jury to say that, let me see if I can get the numbers right this time. I think Justice Wintersheimer last time and I were trying to remember the numbers. It was $6.5 million, so that 30% of it would be $2 million for us. A $2 million judgment is based on a pattern of lies. And we can't allow this system to operate that way. The Kentucky case that's closest on its facts is the Taylor case, which I cite on page 24 of my brief, where an attorney never told the judge about his remarriage. When a lawyer enters into such practices as are admitted and proved in this proceeding, he should expect that the courts will protect themselves and the members of the bar who appreciate the responsibilities of their profession from such conduct. In addition, the people sitting in this room need to be protected from it. The Dunsell case, which I cite on page 27, says the test is if it might reasonably be expected to influence the jury. I mean, I know it influenced the jury. I went back after a colloquy about what the proof was about the need for long-term care and found that the doctor testified that Chad might, for brief periods, have to go into a place like Cardinal Hill. She couldn't remember what it cost at Cardinal Hill. Sure she couldn't. She could remember an expensive place that was $1,000 a day, but that was a brief period of time. She did know that he didn't need to go into any nursing home now when he only weighed 40 to 60 pounds. He wasn't going to get full growth. He was going to get perhaps over 100 pounds. And at that point, Mrs. Watts, that is to say Mrs. Wexel and her husband, wouldn't be able to lift him around anymore. I mean, all the proof is based on the proposition that this lonely widow is in the house by herself. Now, I don't know what the testimony would have been, what the jury would have found if instead of saying my husband...
They didn't award her anything, did they? I mean, this is money for the child, is that?
Money for the care,
Yeah.
and the evidence was that the mother is going to have a hard time
Well, let's
lifting
suppose the
child
jury had known that there was a stepfather and he had been caring for the child.
Well, yeah.
Wouldn't the money have been the same?
Wouldn't it have been a different case, Your Honor, if instead of saying my husband is dead and there's no member of the family around who knows how to do it, to say my husband's there now, but who knows, maybe I'll get divorced. I mean, isn't that a totally different case?
Are you asking me?
Well,
I don't think
I think it's a rhetorical.
I hope it's a rhetorical question,
it is.
right?
But I think under Dunsel, not only might it reasonably be expected to influence the jury, it was intended to influence the jury, and I don't think anybody with a straight face can, I'm not asking you for an answer, Your Honor.
Good.
I don't think anybody with a straight face can say that it wouldn't have been a different trial entirely.
You have 1 minute.
Is it your assertion that this lady actually lied to the jury, or she failed to tell the whole truth?
Oh, absolutely, she lied. Her husband wasn't dead.
Well,
Her
first-
husband, Mr. Watts, was dead,
Yeah,
and she
yeah.
could have maintained the name Mrs. Watts.
She could have.
When she got
She
married.
could have, but she didn't. She
Did
said
she-
my husband
Did
is
she
dead.
say, "I'm not remarried"? Did she actually tell the jury, "I don't have a husband"?
She said my husband is dead.
Well,
There's-
she has a dead husband.
I cited for it. Well, she didn't say one of my. She didn't say my prior husband was dead, Your Honor. There's
Well,
a
she
non-Kentucky
didn't
case
give the
that
entire
addresses
truth.
that. What she did, and the whole pattern of this thing, as found by Judge Knox, she intentionally misled the jury.
So she failed to tell them the whole truth,
You know,
because somebody didn't ask them all the right answers.
It was an outright lie to say that there is no member of the family that's familiar with the care of Chad. That's a lie. There's one that's an outright lie. There's a case that I cite, that non-Kentucky case that said, where they said my husband's dead, and gosh, that was referring to a different husband. I mean, we lawyers can split that hair, but a jury doesn't split that hair. And as Judge Knox found, a jury wasn't expected to split that hair. And I think they can't have been reasonably expected to. In any event, maybe there's
I want to go
something.
back and focus on, for those of us, and I'm confident that the whole court is concerned about this, but the fact is, Judge Knox heard this evidence. According to your version, he was concerned about it, but he finally came down to a conclusion that he was not convinced that it affected the outcome. Now, how can we go beyond that? He heard the evidence. He not only heard the evidence, he heard the trial. He heard the witnesses. He heard it all. What on earth would we be doing? So our view is when he knew so much more about it than
It's the wrong standard, Your Honor. Requiring.
you would urge a prophylactic standard in any circumstance where there is a fraud of this type, set aside the judgment.
There are cases, and I believe the Kentucky cases say that where it might be reasonably expected to. That's all you need to show. I cite some federal cases that make a distinction. Where there's an unintentional misrepresentation, there is a burden to show an influence. Where it's intentional, there's a Kentucky case which I cite in there that says it can never be free of harm.
So if he had said that there was using your test, had applied your test, we would have to be then, that would have to be clearly erroneous before we could touch it.
No, it's the wrong standard, Your Honor. It's an error as a matter of law.
What if he had said, "I'm satisfied"? Would that be better?
If he had said that in no way could it have reasonably be expected to influence the jury, I'd say it would be defensible.
I do want to ask you one question that's different, and that is, you did not address it, and that is this apportionment issue. Is that a major issue in this case?
Well, I think it's an issue. I think the problem from my perspective with that as an issue is that it requires a new trial. But it's absolutely clear that the main wrongdoer in this case, the one that caused most of the injury, not the main wrongdoer. The main wrongdoer was the kid who maybe got drunk and at least drove recklessly. We don't know whether he was drunk or not. But the one that probably, according to the medical proof, caused most of the injury, because it wasn't just bang against the windshield. It was banging around, and of course, if the kid had been in a seatbelt, he would have been able to do it. And the statute did not address, it's been changed again since then, did not address any issue that's related to apportionment. It's not a matter of attributing any liability to him, much less, what do they call it, contributory negligence. Nobody's suggesting Chad was contributory negligent. We tried to offer proof about seatbelts, and it was ruled in limine that we couldn't offer proof. Proof about studies was tendered and rejected. There was plenty of proof on that issue. And indeed, within the limits of the apportionment, if you take the two cases together, the statute even says parties, and the father's estate was a party to the first action. I mean, the Floyd case says you're not bound by the statute. You can increase the statute and do. And in this case, it's barely an increase in the statute to say, well, when we talk about parties, we'll talk about parties to the first action too. And the kid wouldn't have been hurt if he'd been in a seatbelt. As simple as that. I mean, that's the proof we offered. So I think it's important, sure, but you don't have to get to it. And the best way to solve it is to say, come around to the second case, fellas, and if you didn't sue somebody that you could have sued the first time, and it's going to cause a second hearing, and you might get multiple damages, and if there was substantial prejudice, too late. And that'll force people to bring in everybody in the first action. So I think apportionment's, thank you, Your Honor.
Thank you. Mr. Maloney?
Please, this court, ladies and gentlemen, I wish I had more than 7 minutes to talk about a number of these issues that have come up in the Mr. Miller's comments. First of all, I would like to say that there is no evidence in the record whatsoever that these young boys hid their car away. And I invite the court to look at the testimony of both boys who testified, and there was no evidence whatsoever that they hid the car away. Secondly, on the blood issue that was mentioned, the jury found that Todd Neal was intoxicated. We produced more than sufficient evidence that he was intoxicated. We went almost to the lengths of a criminal requirement of chain of custody, beyond what I think is even required in a civil case. But we had the investigating sheriff who said he went to the hospital. Someone, a doctor whose name nobody knows, drew the blood, gave the blood to him or to his partner, a state trooper, and he took it from the state trooper. He says he can't remember whether it was given to him or given to the state trooper, and the state trooper turned around and gave it to him. But then he took it to Frankfurt. It was analyzed in Frankfurt, and we had the lab analyst in Frankfurt to testify as to the results. And that is sufficient evidence for the jury to consider that Todd Neal was, in fact, impaired in his ability to operate the vehicle. And it sounds like that there's still, that the defendants are still fighting the issue of intoxication. Jury finding, and there's been no showing that that was an improper finding by the jury that this boy wasn't intoxicated. I want to talk briefly about the name change, or the name issue, if I may, and then talk about approximate cause, foreseeability, and then one comment I'd like to make about the splitting of causes of action. On the issue of the name issue, I know that this was a trial decision made by us to, on viewing evidence that we considered to be irrelevant as to whether we had any obligation to advise the trial court that we're aware of irrelevant evidence, court, that we know that the case law says can't be introduced. And that was a trial decision as to whether we had an obligation to tell the court that. The issue is this cause of action was brought in a fiduciary capacity by Chad's mother. It could have been brought by a bank. Whether a bank, if it had been the institution bringing this action, went through a name change, has no relevance to the jury. The issue of
Counsel, if it's so irrelevant, then why, why would you climb a tree to tell a lie? Why don't you just tell the truth from the very beginning?
Your Honor, there was no lie told. There was never a reference in the trial transcript of calling Mrs. Watts Mrs. Watts. It was Elizabeth. Now, that was a trial decision, but it gets down to this. It's the only thing.
Did you ask her to state her name?
No, sir. I didn't.
But the trial judge referred to her as Mrs. Watts.
The only time that I can recall that the trial court did that was when the trial court called the name of the case. And I cannot imagine that the jury would have made their decision solely on the way that the trial court called the case to be
I really don't
called
think
to
that's
trial.
Mr. Miller's argument.
I'm sorry?
I really don't think that's Mr. Miller's argument.
No, sir. I think Mr. Miller's argument was that she said my husband is dead. That is a fact. Her husband was killed. And I don't believe that the jury, in the damages that they found, made that determination as to how much to award Shad because of the fact that she said, my husband is dead. When the court looks at the instructions and the damage award, the substantial part of that is for pain and suffering, has nothing to do with the name of Elizabeth Watts. Another amount is for medicals, which has nothing to do with Elizabeth Watts. And then there's a substantial amount for institutional care, which has nothing to do with Elizabeth Watts. And it gets down to this, the way I see it. The appellant is claiming that they've been deprived of the opportunity to misuse this type of information. It has no relevance. If it doesn't have relevance in a wrongful death action for a widow on behalf of her estate, it shouldn't have any relevance whatsoever for action brought on behalf of her handicapped child. And I guess the last point I want to make on that issue is that the trial court, who was in the best position to hear all the evidence post-trial, the testimony from all the lawyers, found that it was not prejudicial, and had it been so, the court would have found otherwise. This court would have to say that that was an abuse of discretion by the trial court. Now, if I may, I'd like to talk about approximate cause and foreseeability. That's one of the main issues, I think, in this case, along with the splitting of causes of action, as to why we're here on our request for this court to take a discretionary review of this case. The proximate cause is a substantial factor. And that is not a matter to be determined as a matter of law. That the jury determined that the sale of alcohol to these minors was a substantial factor for what happened. The jury determined that Todd Neal was intoxicated. The jury also determined that Todd Neal was 70% at fault. And this is not an expansion of the Dram Shop Act. This gets down to the whole issue of foreseeability.
Is there any other case, counsel, where in Kentucky where we're talking about acts other than acts of the actual buyer? I mean, it seems to me that it is an extension of the Dram Shop.
No, sir. The only other ones I'm aware of, and I know I can't cite specific cases that I haven't cited in my brief, but I can give an example. In cases where a minor sold a weapon illegally, gives it to his friend does something and somebody gets injured, that's the foreseeability, that you don't sell weapons to minors. And the court in the Grayson case said that minors and intoxicated people are in a category that are not allowed to have alcohol because of the foreseeability of what may happen. And I think maybe...
Does that foreseeability include the transfer from the purchaser over to someone else?
I would submit, yes, Your Honor, for this reason. If the court feels that a minor shouldn't handle alcohol because of the immaturity and the lack of experience of handling alcohol, the court certainly, within the reasonable inference of that intent by the legislature, should say that a minor, because of that inexperience, is going to share it with other minors. And I think the best way to crystallize that would be anyone who saw a 16-year-old boy walk out of a liquor store on a school day at 10 o'clock in the morning with a case of beer and a pint of rum could easily conclude that he's not taking it home to give it to his grandmother.
Even if we were to assume in this case was secreted away and the clerk couldn't see it, and this Charles went in and bought for these other kids, you think there should be liability in the case?
I think, yes, sir. When you violate the law and sell alcohol to a minor, or if you violate the law and sell it to someone who is stumbling drunk, you have to realize that there is a foreseeable consequence that something bad could happen. You don't have to have the crystal ball to say exactly what's going to happen, but it's a reasonable extension of the foreseeability doctrine under Pike versus George and Grayson that a minor is going to do something stupid, silly, or irresponsible ingesting alcohol. Whether they ingest it and give it to other people, only by injure somebody there is foreseeability. But I think it gets back to, this is not walking in there and asking for one can of beer and walking out. This boy purchased a case of beer and a pint of rum.
Isn't that the distinguishing factor? Otherwise, it seems to me you have an inference on an inference.
Yes, sir, I agree.
Unless you have 24 of these, or however many there are, in a case.
I think I would have to acknowledge that as being correct, Your Honor. And also I would say that as far as causation, there was evidence at trial that this young boy Todd Neal, who was the driver, consumed between 5 to 9 beers. That back to this is not walking in there and asking for a can of beer. Now, this boy purchased a case of beer and a pint.
Is that the factor? Otherwise, it seems to me an inference on an inference.
Yes, sir, I agree.
Unless you have 24 of these, or however many there are, in a case.
I think I would have to acknowledge that as being correct, Your Honor. And also I would say that as far as causation, there was evidence at trial that this young boy, Todd Neal, who was the driver, consumed anywhere between 5 to 9 beers that at best they could recall. Conceivably, he may have drank more. We know that his blood alcohol a number of hours after this accident, like about 3 hours after this accident, was a .09. And we had expert proof by a blood pathologist and toxicologist, Dr. Irene Rokel, as to the effects of anything over, I think she said a .04 on the human body, whether it's an adult or a minor. But here's a young boy, an inexperienced drinker, with a .09 3 hours later, or a number of hours later. I don't want to say 3, but it was, he was transported over to Lexington, and that's where the blood was drawn, and the accident happened in Scott County. So I think that is, yes, sir.
Counsel, can you refresh my recollection as to the record in this case? I know it's been going on since 1984.
Yes, sir.
But is there a diagram of the location? I'm speaking about where was the car parked? What does the building look like? The Newtown liquor store, whatever.
My recollection is there was no diagram. There was some testimony as to the layout of the building. There was testimony of glass windows. There was testimony by the owner of the store, not the owner, but the manager of the store, that there was boxes stacked up in front of the window, and obviously the purpose of that was that his view would have been obscured looking out into the parking lot. But there was...
How do you know that? I mean, where do you get that?
Well, one of the manager testified...
We put boxes
No, that
up
was
here.
the inference argument to the jury that his view. Now, I'm not suggesting that. I'm not suggesting that the boxes were even stacked up, but there was evidence introduced. The other thing is...
That's not your theory at all.
No, sir, not at all.
Counsel,
yes,
I'm interested in what limits you should be on cause. This alcoholic beverages were purchased in the morning. My recollection is the children went back to school. They separated. 2 went one way and nothing happened. 2 more went another way, and of course a disaster happened. Now, instead of this happened, late in the afternoon, 4 o'clock?
It happened, I think, around 2:30 going on 3 when school let out.
Okay, so we're talking about somewhere 4.5 to 5 hours after the beverages had been purchased and after the kids had gone back to school. Is there some point along that way there, or where causation would be cut off? You understand what I'm saying?
I do, and
what if this had happened instead of that same day? What if it happened 4 or 5 days later? At what point does the causation cease?
I think that's an interesting question, and I don't think that it would. I would think the court would find it difficult to draw that line until the state of Kentucky, or the Commonwealth, that it's going to take this many beers with this many hours before we're going to allow recovery. I think it becomes a jury issue as to what is a substantial factor and what is foreseeability. The evidence was 5 days later that they had an accident. I suspect that a jury is going to have more difficulty in finding liability, but I guess the court could conceivably say, yes, if the boy took it and secreted it for a party weekend and went out and did something and injured himself or a passenger in his vehicle or a third party coming down the road, I could see circumstances where the court could say yes, because you're still violating the law, you're still selling to a minor, and that minor, if it doesn't abuse the alcohol at that given time, hour, or day and does it 5 days later, I could see circumstances where there would be liability.
Mr. Maloney, why didn't you sue the liquor store when you filed your first lawsuit in 1985?
I would like to answer that for you, and when I do, I'm going to be stating things that are not in the record. But that was a decision made by me as to what I interpreted the state of the law to be at the time under Pike versus George. And that gets right back into whether we're impermissibly expanding the case law, which I don't believe we are under Grayson. But at the time of this accident, Pike versus George was the law. And that was a case where minors purchased alcohol, went out and had an accident, and I think people inside the car plus the driver were injured, and there were suits there. It was not involving a third party. Grayson came along after the settlement of this case and before the refiling and said, we're going to extend it to intoxicated people. And in Grayson, it wasn't a minor who gets drunk and goes out on the roadway and injures a third party. And I felt like that there was a better chance of a recovery under the Grayson case than we had under Pike versus George. And that was a interpretation of the law by me. Mrs. Watts could have gone to another lawyer and maybe gotten a different opinion. Perhaps I wasn't as judicial, wasn't as much of an activist in interpreting that law at the time. But I looked at it as Grayson, as being the case that will allow us to go forward with a third party. If I may, I'd like to talk a little bit about the splitting of the causes of action.
1 minute,
Yes,
Mr. Malone.
because this is the reason why we're here. This issue of Dan Watts' estate is a red herring. There was no evidence at trial whatsoever that he was negligent in causing this accident. There was evidence that Chad Watts didn't have a seatbelt, and we've already talked about the fact that the seatbelt law at that time would not have permitted that to even been introduced as evidence at trial. So to show that Dan Watts minding his own business, driving down the road on his lane, and a boy passes up two or three cars at 100 yards on the wrong side of the road and runs into him, I think is stretching the imagination to think that there could be liability. And the trial court held that there was insufficient evidence. Now, in splitting the causes of action, and if I may just have enough time to complete this thought, if there had not been a filing of a lawsuit and there had been a settlement only, with the disability statute, we could have waited 5, 10 years and filed a lawsuit against the liquor store. Now, the fact is, you want me to stop? Thank you.
All right, thank you very much. Recess court for 10 minutes.
All rise. Supreme Court stands in recess for 10 minutes.